My good friend Joe Onick, who's counsel to Pelosi, and so he came up.
So are we on our own here? Yeah. Okay, so I guess I need no introduction apparently, so we're going to get started. My name is Merrick Garland. I'm a judge on the United States Court of Appeals for the D.C. Circuit, formerly an assistant U.S. attorney and a Justice Department person.
Known as the second most important circuit in the country.
Right, exactly. No comment. Yeah.
It begins. You didn't even let him get a sentence out of the way.
But I got the last word here. So today we're here to discuss the role of the Department of Justice in two dimensions. Its relationship to the White House on the one hand and to the DOJ field offices, that is, to the offices of the United States attorneys on the other. We're going to begin with a panel discussion, and we're going to try to save the last 20 to 30 minutes for questions from the audience. We have a man with a microphone right here, and so if you're going to, when it comes to that time, sort of wave at him, and he'll run right over to you. We have an unbelievable panel with respect to their knowledge of these issues, and so I'm very happy to introduce. First unbelievable member of the panel is, well, she's actually believable.
Which Judge says something.
It's Judge Fisher who's unbelievable. Yeah.
Touche, he got the last word.
Jamie Gorelick. Jamie is now a partner at Wilmer Hale. Just saying those words tells me how old I am. She was a member of the National Commission on Terrorist Attacks on the United States, also known as the 9/11 Commission. Before that, she was vice chair of Fannie Mae. Before that, she was Deputy Attorney General of the United States in the Clinton administration. Before that, General Counsel, Department of Defense, and way before that, graduate of Harvard and the Harvard Law School. On her left is Viet Din.
One time only.
I'm in the middle of the road here.
Currently professor of law at Georgetown University Law Center. From 2001 to 2003, Viet was Assistant Attorney General for the Office of Legal Policy. Before that, he was an Associate Special Counsel to the Senate Whitewater Committee. Before that, he was a law clerk for Judge Lawrence Silberman of the D.C. Circuit and for Justice Sandra Day O'Connor of the Supreme Court. And before that, he graduated from Harvard College and Harvard Law School. Next, Judge Ray Fisher, since 1999, judge of the United States Court of Appeals for the Ninth Circuit. From 1997 to 1999, Ray was the Associate Attorney General of the United States. Before that, he was a partner in Heller Ehrman, and before that, Tuttle and Taylor, both in Los Angeles. He clerked for Judge J. Skelly Wright of the D.C. Circuit and Justice William J. Brennan, Jr. of the Supreme Court. Before that, he graduated from the University of California at Santa Barbara and from Stanford Law School. And on the very far left, we have A.B. Culverhouse. He is the chair of O'Melveny and Myers. Most important for us, that means he is the boss of Walter Dellinger.
I'm not sure Walter would admit that.
He currently serves as a member of the President's Foreign Intelligence Advisory Board, to which he was appointed by President Bush in 2005. From 1987 to 1989, he was White House counsel to President Reagan. From 1973 to 1976, he was chief legislative assistant and counsel to Senator Howard Baker. He is a graduate of the University of Tennessee and of NYU Law School. All right, we have a very big audience here, and we appreciate it, but we hope you won't be disappointed. I will not be asking questions that are ripped from today's headlines. To the contrary, because some of the members of the panel may represent some players in those headlines, and because some of the judges on the panel may someday see representatives of some players who are in those headlines in court, we're going to try to intentionally avoid that. For that reason, the questions will be theoretical, hypothetical, or historical. I would be grateful if those of you who ask questions from the audience try to put the questions in those terms. So here's my first purely hypothetical question. Suppose that the President of the United States appoints his friend, a former judge and advisor from his home state, as the Attorney General. Suppose that a public interest group, say Common Cause, then criticizes the Justice Department as being, quote, heavily politicized, close quote. and claims that the Attorney General has not, quote, sorted out the distinction between being the President's lawyer and the people's lawyer, close quote. Suppose that a member of Congress from the President's party repeatedly calls the White House and the Justice Department to request the removal of his hometown United States attorney. Suppose that the White House thereafter tells the member of Congress that it will, quote, expedite, close quote, the dismissal of that U.S. attorney, tells the Justice Department to do so, and then the Justice Department terminates the U.S. attorney. Now suppose that it comes to light that that member of Congress who called the White House was under investigation by that same U.S. attorney, and suppose that the U.S. attorney tells the press that, quote, a call from a congressman clearly expedited my removal, close quote. Finally, suppose that the President at a press conference says, quote, I see nothing improper in the handling of this case, and then says he would do the same thing over again if he had it to do over again. Okay, so you got me. It isn't really a hypothetical at all. To save the panel the embarrassment of telling me what it really is, since this is a surprise to them, who in the audience knows what this really is? Anybody know who the President was or is? Right. The President was Jimmy Carter. Every quote is correct. Who was the Attorney General? Some of you are old enough to know the answer to that.
Griffin Bell.
Griffin Bell, right. A former judge from Jimmy Carter's home state, Georgia. Who was the member of Congress? None of you know that. Joshua Eilberg of Pennsylvania. And who was the U.S. Attorney? David Marston of Philadelphia. This was the first scandal of the Carter administration in the first year that the Carter administration was in office. So let's use this historical example to explore both sides of the question. First, the White House DOJ contact, and then the DOJ U.S. Attorney's Office contact. So I'll leave it up to the panelists to decide who wants to answer first. Did President Carter do anything wrong when he called Griffin Bell, and by the way, he conceded at a press conference that he did do this, and asked him to expedite the dismissal of United States Attorney Marston? Anybody have a view? Was it okay for the President, after having been called by a congressman, to call the Attorney General and say, let's get moving on this guy?
Can I start by just not answering the question, just pointing out the two fault lines that may make it into something nefarious? As you articulate the historical example, I didn't know. I was in a bunker somewhere. I wasn't here. But or refugee camp, I think was exactly what the date.
This is 1977, so that's probably right.
Refugee camp. The two breakpoints there that is not in the facts as you articulated them is, one, whether the congressman told the White House the reasoning behind his wish for removal. Absent that knowledge from the White House, obviously the U.S. attorneys are political appointees recommended by and denigrated by political actors, including the responsible local representatives. The second point is whether or not it is indeed true what the U.S. attorney ultimately said after his dismissal, that the sine qua non of his dismissal was his aggressive investigation of the congressman. Okay. I think absent those 2 points, everything sounds like hardball politics, subject to the president's power to appoint and remove U.S. attorneys at will.
All right. So it's fair to answer a question with a question. So I'll fill in a little more fat. Maybe A.B. knows the facts.
Well, I mean, I don't know the facts, but I think this all depends on whether the president knew or didn't know that the U.S. attorney was investigating the congressman, because I mean, those kinds of calls are not unprecedented. And in my view, I mean, the system clearly, I mean, assuming the President Carter didn't know, then, where did the system break down? Because at some point between the call to the congressman and the firing of David Marston, the fact that the congressman was under investigation should have been taken into account.
All right, so I'll eke out the facts a little bit more as we talk. So what Marston told the president was, Jimmy, this is the first year of a Democratic administration. Marston was appointed by President Nixon. I want a Democrat in there. There's no reason why we have to keep a former, a member of a former administration. That's all he told us. So now what? Is this okay?
Okay.
Absolutely.
Well, I'm not so sure, because it seems to me that if you're
You
looking
can
at...
always fire a Republican in D.C. It's when Republicans fire Republicans. That get you. Democrat fire Republican, that's fine.
A.B. or Ray?
no,
My concern is there's a lot of passivity here, and there's a certain responsibility on the part of the Justice Department, the AG, or his advisors, to not let it be just a singular question or a singular statement. It would seem to me that the criminal division certainly would know that there was a pending investigation. Somebody should have run a flag up so that there wouldn't be any question about it, and then they could debate it as to whether or not the traditional notion of firing incumbent U.S. attorneys appointed by the prior administration, I don't see any problem with doing that. What I do see is where there's a impending or a pending investigation, and it depends on what Marston's role was in it. If he was removed, pretty removed from it, prosecution would have gone on in any event, then that diminishes it. But it seems to me acting out of ignorance is not an excuse if you're the Attorney General.
All right, well, let's go back to the President. You're Jimmy Carter. You get a phone call from a congressman of your own party. The congressman says, it's time for a Democratic U.S. attorney. You know, what's going on over there? Let's go. What should Carter do at that moment? Can he call the call the Justice Department? In this case, he called Griffin Bell directly. And can he say, what's going on with this guy? Is there an investigation of this guy? This guy called me and wants to start have a new U.S. attorney. What should the President have done under those circumstances?
Well, the appropriate thing to do is to say to the Attorney General, if this is a matter of having our own person in, that is, that's something we ought to be doing. If, in other words, there's no reason why a Democratic president should have a Republican U.S. attorney. These are political appointees. But it seems to me that the President needs to say to the Attorney General, I want you to look at this and make sure that there is could be no suggestion that any action by us is intended to influence the outcome of a case.
What if Eilbert, now he didn't do this, but what if Eilbert said, I actually am under investigation, and it's all because this guy is a partisan of the other party. It's a totally unfair investigation, and you should at least look into it. What should the President do nothing? Should the President pass that on to the Attorney General? What should he do?
Well, I think if there is a complaint about the politicization of a U.S. attorney's decision-making, whatever the party of a U.S. attorney, the Justice Department has the right and obligation to look into that to make sure that that's not the case. And there are various ways, as Ray pointed out, for doing that. One of the reasons you have the capabilities you have in Maine Justice is to exercise oversight over the U.S. Attorney's offices to make sure that matters are being handled according to the best traditions of the department.
Any disagreement on that?
Well, I mean, at some level, and this is the reason why all of us have dealt, I've really tried to enforce a process that should work, where those calls are handled by the White House counsel and the AG or the deputy AG, and there's a lot of nuance. But anytime a congressman calls and wants a U.S. attorney fired, people's antennas should start quivering. Or a senator, it is, in my experience, fairly unusual, and I would be very wary of that. Now, I'm not sure I would expect a president to have those rarefied antenna, but hopefully you could educate the president that he should tread lightly and call in the White House counsel and let it be vetted. Hopefully the Attorney General or the Deputy Attorney General receiving those calls, as Ray said, would his or her antenna would start quivering and would make sure that there's not something that people are missing here that is incredibly relevant to the decision that is about to be made.
It goes to the core of what people expect from the Department of Justice. Any of us who've practiced law have had to tell dozens and dozens of clients, no, you're not being prosecuted for political reasons. The Department of Justice doesn't do that. And the moment you have prosecutions that look like they are being made, or for that matter, not being brought for political purposes, you undermine the entire core of what the Justice Department stands for, and on a practical level, its efficacy.
I think, Merrick, one of the things that needs to be, I think AB has touched upon it, brought to the surface is there's an implication that there's something wrong with Jimmy Carter calling the Attorney General. The Attorney General is part of the administration. He's a cabinet level, or she's a cabinet level official, and there ought to be free communication there. The constraint, which is what I think Jamie's hitting on, is that the Justice Department has this other role. You adverted to it in the hypothetical, but I don't think, I can speak as someone who came from total ignorance of what the role of the Justice Department was before I came into the Justice Department. I had no idea. I was a civil business trial lawyer. I wasn't a assistant U.S. attorney, so I didn't know about the institution, and I didn't appreciate what its institutional values and structure was. And I think somebody who comes in from the outside, somebody who isn't, even if they come in as the Attorney General, may not be fully aware of that. The traditions may be different. If you're a district attorney or you've been a state attorney general, the Justice Department does have a tradition and a long history of professionalism. And if it gets, corrupted from the top through ignorance or through willfulness, that's a problem. So the Attorney General has that role and that institution to protect, but the other hat the Attorney General wears is counselor of some sort to the President. And now, as AB has said, we have the institution of White House counsel, but White House counsel is not, it's of relatively recent vintage, so perhaps at some point, those of who know the history better than I might talk about that too.
Okay, so we'll pass in just a moment to what AB raised, which is a series of letters from and orders of attorneys general funneling communications between the White House and the Justice Department between specific offices. But before, let me at least tell you what happened in this case. So, in fact, before Marston was fired, Bell sent a team of 3 Justice Department lawyers down to Philadelphia to find out whether removing Marston would make a difference in the investigation. They assured him that it would not, and Marston was fired. As you can imagine, the members of Congress of the opposing party did not believe that was sufficient. If somebody is, and just to finish this, if somebody is under investigation by a sitting United States attorney, is it ever appropriate, in a political case like this one, where, in fact, the entire Democrat, I shouldn't say that's a bit much, but many Democratic members of Congress from Pennsylvania were under investigation at the time, is it appropriate, even if the office can go on without that United States attorney, to remove that United States attorney after the request for removal comes from one of the targets?
I think you have to separate out the 2 different issues, right? Let's leave aside the propriety of the request, and I know it's artificial because it's all part of the whole controversy. But the decision whether or not to remove a U.S. attorney, if it has no implication on pending investigation, especially when there is a natural reason to do so, that is a change of administration, I think has to be able to be made independently. Otherwise, the alternative is one of the draconian removal, which is, I think that line of reasoning would justify only one course of action, which is ask all 93 U.S. attorneys to tender their resignation, as Attorney General Janet Reno did, or as the White House counsel suggested at the beginning of the second Bush administration. Think of that, if that's the case, because we're also concerned that at any given time there are sensitive cases dealing with politics, friends of politicians, family members of politicians, if not politicians themselves, then the only way in order to effectuate policy changes through personnel is to do it wholesale. If that's the case, you're going to lose a whole lot of good talent without any good substantive reason.
All right, so let me get to the point that AB started to raise, and I'm not sure exactly the timing of this, but starting with the aforementioned Griffin Bell, it's possible that it happened with Ed Levy, and we're not really sure. We haven't found one. The attorneys general have issued every other year or so, and I think every single attorney general since then has issued a directive limiting the communications between the White House and the Justice Department. So I'm going to ask the members of the panel whether they think that's a good idea, and whoever is the first member of the panel to answer that might describe the way in which communications have been limited. Jamie, you're looking like you can do that.
Sure. I'm happy to do it. I would pause first to say that there actually is or was a policy of the Department of Justice limiting contacts between the Department of Justice and members of Congress for just the reasons that we described. And I have my version of that letter, which I was asked to make sure I sent, as my predecessor had, by members of the opposite party in the Senate. So I would say, before we leave the other topic, that I would say that there has been bipartisan support for the notion that you don't want to have members of Congress looking like they're getting special treatment, and that you want to preserve the ability of the Department of Justice to proceed in politically sensitive cases without interference. So, having said that, if it has been longstanding practice of the Department of Justice to limit the ways in which communications between the Department of Justice and the White House can happen. That is with respect to enforcement matters. Obviously, things like legislation, appointments generally, grant making, those kinds of things, there are many avenues for communication, as well there should be. National security matters have special procedures. But for the enforcement matters, these are handled with care for a very good reason. For up until the beginning of the Bush administration, the number of people who could have these communications was purposely limited. So under Janet Reno, it was the White House counsel and deputy, and the deputy attorney general and principal associate, and who had the communications. Obviously, the attorney general could have those communications in any event, but it was very limited. Starting in the Bush administration, the communications were limited to those offices. And once you do that, of course, you end up with probably hundreds of people who can have the communications on either side of the communication.
Okay, well, before we get, maybe Viet wants to respond to that. Actually, something important did happen when the Bush administration first came into office. That was 9/11. Did that make a difference, Viet, do you think, with respect to how easy communication should be between the White House and the Justice Department, even with respect to enforcement matters, because some of those enforcement matters involve terrorism cases?
Yeah, let me just stress that I was not involved in the policy or the discussion dealing with this, so this is just as a bystander and observer. But I do think you do strike on a very important note. That is, after 9/11, almost every single one of our contact with the White House has to do with counterterrorism or counterintelligence of some sort or another. That's because everything we do in the administration had to do with counterterrorism or counterintelligence as a principal response of the nation to the 9/11 attacks. And at the same time, the Department of Justice was running the most extensive and expansive criminal investigation in the history of the nation, Pen Bomb 2, as well as the most extensive and expansive intelligence operation in the history of the nation. And the White House, responding to the national emergency that was 9/11 and continuing threats that the terrorist threat posed, naturally wanted as much information as possible. I do think that expanding the number of people capable of briefing the White House removes the artificial backlog or bottleneck that would result if you only had 3 from one side of the equation and 4 on the other side of the equation who can facilitate these types of very critical conversations. The question, obviously, is how much do you want to expand it? and how important is the information. I do not think that when a national priority, a national emergency as that happens, that you want to have an artificial bottleneck. You want to put the substantive checks in there in order to prevent misuse of the more liberalized policy. We can have a conversation as to whether or not people were properly trained and proper procedures were put in place to ensure the complete perception of impartiality in the administration of justice. But I don't think we should do it by imposing shoe leather costs, a bottleneck in the communication change, but rather we should implement substantive rules and regulations and make sure that those who are privy to the communication chain think of themselves and appreciate the nature of the information and the nature of responsibility that they are thereby engender, which is the responsibility to enforce the law regardless of the identity of the victim or the perpetrator.
Can I make 2 quick points about that? The Ashcroft memo maintains the categories that the Reno memo had. That is, in criminal and civil enforcement and national security matters on the other. And I have no problem with the general notion that if you are pursuing a national security matter and there are national security implications to a criminal enforcement matter, that poses a special problem that needs to be dealt with greater communication, probably to different people, including the National Security Council, which is in both sets of memos. But I don't think that you can have that swallow the rule. There are still ordinary criminal and civil enforcement matters that have nothing to do with national security. I think that the impact of 9/11 was just wholesale communication, and it just got in the, people just got in the habit of having lots of communication back and forth between the Justice Department and the White House on a whole raft of issues, and thus the discipline went out of the system for that reason. So I think it had a practical effect rather than a sort of doctrinal one.
Yeah, I think that, and that's the point I think I wanted to return to, whether or not once we expand the scope, once we expand the circumference of the pipe, whether or not we make sure that those persons who receive the information at either end of the pipe is respectful enough of the sensitive nature of that
I don't think you
information.
I don't think you can train hundreds of people to sufficiently protect the decision making with regard to sensitive cases in the Department of Justice. I don't actually think it's a practical matter. You can protect the career person who is making a decision about a sensitive criminal case if you have the possibility of literally hundreds of people from the White House calling that person directly.
Now, are we in danger of overstating the problem simply because the document is there? Because,
I don't know.
Because part of the issue, and I'd love to hear how our predecessors' experience was. Part of the issue is that the memos only regulate the initial contact. So as a technical matter, I guess the Attorney General can call the White House counsel and says, by the way, we started pent bomb. And, you know, and so thereby let's set up procedures for subsequent contact of pent bombs. People can communicate directly with FBI and DOJ, and thereby not creating that kind of problem. And so the regulation, both from the civil levy era all the way up to the April of 2002, only regulated the initial contact and does not regulate necessarily the subsequent contact related to that particular case, or there may be alternative procedures that may be set up. And so, one, we may be overstating the problem. The second is that the nature of that kind of workaround, which is we started pent bomb. You know, are we now free to communicate about everything else? Is the anthrax investigation part of pent bomb or something like that? I think seems to me a little bit too much of a paperclip and Band-Aid fix rather than a more substantive review of the policy.
I guess I have the question of practicality and discipline. Rick Griffin Bell was quoted, maybe quoted himself, saying when somebody came to him that the White House wants us to do something, and his response was, the White House is a building, give me the name. And there are lots of people in the White House, and there are lots of people in the Justice Department, and if you have people freelancing because now they think they speak for the White House, and somebody at Justice is told X from the White House is calling and doesn't know who X is other than that they are from the White House, then the people who are high enough up the chain of command who want to control these communications to have some discipline in it may lose control. There is, in fact, very good reason, as you say, not to create bottlenecks, but at the risk of undoing bottlenecks, you create chaos. And, I mean, the Katrina disaster was famously attributed to the fact that the Secretary wasn't being, there was an end run going around the Secretary of Homeland Security. So if it gets out of control, things can go wrong. And so I think there's a balance there.
Well, let's talk for a minute about what goes through the bottle's neck, regardless of how wide it is, right? So are there some things that cannot go through, no matter who makes the statement? Is there some kind of contact between the White House and the Justice Department that should not happen? Yeah. A.B., you're nodding. On what subject?
I mean, this is an art. It's not a science. It's judgment. It's instinct. But investigations involving president, vice president, White House staff, their families, don't go through the bottleneck.
So what happens, again, purely theoretical, hypothetical. So imagine the President of the United States' brother.
He's in the peanut business, right?
Sort of,
Not against that
but it
administration.
involves Libyan peanuts. And the Justice Department catches wind of the fact that Libya is thinking about, or maybe actually did, make a payment to the President's brother. And the people in the Justice Department, or maybe the Attorney General, says, gee, you know, we've got to warn the President, because the President may not know that his brother is now an agent of a foreign power and may be trying to get him to do something that would not be in the interests of the United States. Or imagine that there was an investigation of, I don't know, campaign finance, and maybe some country in Asia is thought to be contributing to members of the President's party, and the Justice Department wants to warn the President or the Vice President or anybody else or the NSC that, gee, you know, there may be infiltration by a foreign government here. Be careful. Can they do that?
Yes, but that's the other end. I mean, I'm talking about from White House to Justice. I think it's time-honored that at times the Justice Department, I've never sat there, but I assume after a lot of deliberation, Eric and Jamie and Ray and bringing all of the people with equities in should give the President.
Is that ever going to look good?
No. No.
It's never going to, but the reason I responded to Viet the way I did is because I do believe that in the area of national security and foreign policy, even when you have a criminal investigation, you have a set of obligations to the President of the United States and the National Security Council to inform. You know, you have to be careful. So in this utterly hypothetical situation in which the Chinese are trying to buy our government with campaign contributions, you would perhaps want to make sure that whatever you said had no ability to undermine the criminal investigation, or you minimize that possibility while alerting a hypothetical Secretary of State on her way to China that the Chinese are up to no good.
Do we have any disagreement among the group of the four panel members on this question? Is it appropriate, even if it's a close relation of the President, relative, political, business associate, friend?
Can I just say something here?
Yeah, please.
I know, I'm used to interrupting you.
Be my guest.
This is one of the reasons why you don't want to have 100 people making that decision.
Are you back on that again?
I am. I think it's, I try, you know, look, one of the things the Deputy Attorney General tries to do is to run a department so that it is run appropriately. And you can't make sensitive decisions like this. As A.B. says, this is an art, it is not a science, and you have to have discipline. If you could imagine a judgment like this being made by any U.S. attorney or any one of the hundreds of staff people who work directly or indirectly for the Attorney General or the Deputy, you could get really bad decisions. So, my feeling about this is the decisions need to be made with great discipline, taking account of the multiple responsibilities that the
But with
department has.
respect to the interrupter, imagine that the person on the other end of this narrow group that you're allowed to talk to is the person whose brother is under investigation. And you can't avoid that person because that person is the president or the White House counsel or the head of the NSC or something like that. Does anybody here think that under those circumstances, the Justice Department should let the investigation run and should not advise the White House? How about the audience? Have we got somebody who can disagree on that subject, or does everybody think that's
By the way,
correct?
you can do that without revealing that there's an ongoing FISA investigation or criminal investigation going on, right? I mean, you can do it in a way that is not.
I'm going to make it harder for you. That is, in the sense that I'm not worried about the question of how they got the information, but the Justice Department is doing an undercover investigation. They would actually like to see the Libyan person pay the president's brother, and then would like to see the president's brother pay the president. Not because they're trying to get the president, but because they're trying to get the president's brother, and this would be the proof. Obviously, if you disclose it, forgetting about grand jury, forgetting about FISA, search warrants, Title IIIs, you end that undercover investigation.
Well, on the West Wing, the president would agree to go along and be part of the sting.
In 24, they tortured and killed the president's father.
Touche on both counts. Okay. I guess we got no audience. We'll get audience participation later.
Well,
but
this is a hard one,
Yeah.
but
that's why I ask. I know the answers are easy ones.
This is a good hypothetical, but it's not very hypothetical. And if you've been in that position, you can't risk that the Libyans are going to have a hold over the president of the United States. You just can't risk. You can't risk that the Chinese are going to have bought influence broadly within our government. I mean, at some point, the natural and traditional role of the Department of Justice has to give way, to a certain extent.
Merrick, I mean,
Yes.
but change the hypothetical a little, and
They're always doing that. They can't answer that.
No, but let's assume that the Department of Justice was investigating where the president's brother had committed tax fraud in the past. I mean, you don't have the kinds of considerations that Jamie is talking about. And in that case, I would expect that the Department of Justice would say, we don't need to give the president. And probably
One of the
shouldn't.
questions I was asked in my confirmation hearing was, have you discussed Madison Guarantee Bank and the RTC, and these are all, the scandals at the beginning of the Clinton administration, with the White House, and would you promise us that you never will? And those were more sort of routine criminal investigations. And no, you wouldn't.
Okay, so now do we have agreement on both sides of this? That is, if it's a case involving national security, depending obviously on the case, it might well be okay. If it's a case involving run-of-the-mill corruption, run-of-the-mill criminal violations, you would not tell the president?
In our circuit, we do these on a case-by-case basis.
No advisory opinions in your circuit? Well,
There's no law in that circuit.
all right, I'm going to exert my authority as moderator here. Does anybody think
He won't believe that when he comes out and argues a case.
Does anybody think it's appropriate to not tell the President of the United States? After all, we have a Constitution which gives him or her authority over enforcement of the laws, to not advise the President of an investigation. Assuming, of course, I'm going to start with the assumption that there's no evidence the President is actually personally involved, other than to be the target.
The operative phrase in all of these memorandum, I think that we can all agree on, is relevant to presidential duties. Right? We at the Department of Justice should, and therefore I argue, have the obligation to apprise the president of facts, including ongoing criminal investigations.
But Viet, can I ask you, do you think there's anything in the executive branch that is not relevant to the enforcement of the president's duties?
Pretty hard. Although in these kinds of circumstances, I actually think that there is a case to be made that particularly in very sensitive the cases of either party, that you should bring it to the attention of the president and his close advisors, precisely for the fact that it affects a whole host of judgments and duties that he has to be apprised of. Not the least of which is, he has to deal with these members of his own party and opposite parties on a daily basis, and he needs that kind of information in order to make the judgments he deems necessary.
So to warn the president or the vice president or anybody else in the White House off about a congressman who may be dirty and who may be trying to get something from the White House and should be advised, the president should be advised that this congressman is under investigation?
Again, it's a matter of judgment and phrasing, right? I wouldn't say at the beginning or an ongoing investigation that you quote unquote warn the president off, because the natural answer is that have you got enough to indict? If not, if yes, why haven't you indicted him? If not, why are you telling me to warn off, not deal with him? I think there is a sensitivity there. In terms of judgment as to when and what facts to disclose, and let the decision maker make the assessment himself or herself.
Well, let's parse the hypothetical a little bit, because if what you're asking is, do you warn the White House that the president may be meeting with somebody who's under criminal investigation, that happens every day, and it should. I mean, the FBI...
You don't mean that the president meets every day with somebody under criminal investigation?
No, the warning happens
Yes,
every day.
okay.
The warning, and as I think it's appropriate. Now, if you obviously have to consider whether there's some bit of knowledge that could undermine an investigation when you do that. But in general, on the one side, you do want to warn the president that somebody's possibly meeting with is under investigation. On the other hand, I think you serve the president and serve him or her in carrying out their responsibilities as president if you insulate them from decision making on a criminal case as to which they should have insulation. You don't serve a president well by inviting participation by the president in a decision that should be made, straight up. On the basis of traditional and appropriate criteria.
Any disagreement with that? So, as actually happens, the Secret Service has a list of all the people who are going to be meeting with the president. And as part of their protective duties, they automatically send Social Security numbers, et cetera, to the FBI, sometimes to the U.S. Attorney's Office, sometimes to the Justice Department, or sometimes to the Justice Department and then to the U.S. Attorney's Office. And is it appropriate for the Department or the Bureau to warn that this person you're about to meet with is under investigation?
Yes.
Absolutely.
Absolutely, and it's done all the time, and it is, the Secret Service comes to counsel's office and says, these 25 people, there are 2 on the list, and the counsel's office takes them on the list, and no one ever knows why. And it's done on a basis of institutional faith. I mean, the Justice Department, the FBI trusts the Secret Service, counsel's office trusts the Secret Service, and and we don't know why Joe Smith, shouldn't meet with the president, but he shouldn't meet with the president. We've been told by the professionals in the administration.
All right, let's ask from the other point of view now. What about what the White House can tell the Justice Department, not what the Justice Department can tell the White House? Can the White House tell, having thought about the problem, and in this case, let's make the White House the president, direct the Attorney General to indict someone? Can/should?
2 different questions.
I figured you'd get to the should after the can.
Yeah. Can, yes, should not.
Should never?
I'm sure you could come up with a hypothetical.
Right.
Well, no, I mean, let's get to a real-life example, Noriega.
Yeah.
I mean, that was teed up by the Justice Department and the national security community, but ultimately the decision was the president's.
Does anybody here think that, no, the president should not have been the one to decide whether the head of a foreign state should be indicted? Instead, it should have been left to the local U.S. attorney in Miami. Put that way, I guess the answer is no.
As Merrick knows, there's an exception to every rule, and the one exception to it seemed like after Noriega, every third U.S. attorney in the Southeast wanted to indict another foreign leader. And after seeing how much publicity their colleague got. So, and in one case, we didn't find out about it until the U.S. attorney called a General Southern Command and asked for assistance in going to apprehend the person. So,
No bottlenecks there.
He was in White House.
So, I mean, it's. It's the president's job. That's why he or she is there to make that decision, in my view.
So, I mean, the classic worry about this was during Watergate, the Dita Beard ITT issue. This was a civil antitrust case against ITT. No one's even heard of ITT anymore, but it was International Telephone and Telegraph. I think
It was a big company.
they still exist, but they made telephone equipment out for countries outside the United States, mostly, and provided telephone service. And at least I'm not even sure whether this turned out to, this wasn't just an allegation, I guess, that there was a payoff involved to try to get the White House to direct the Justice Department to indict AT&T, or to not indict, I'm not sure which. Is there ever a situation in a civil case, particularly, for example, an antitrust case, where the White House should be involved in the decision whether to charge in civilly?
Well, we had the Microsoft case when I was there at the Justice Department, and that was going to be obviously a front page story. It was well considered, heavily vetted within the department, and I would assume all of these hypothetical situations, criminal or civil, that you're talking about with the president or the White House involvement, never are there to override the professional judgment, the ethical judgments of the Justice Department as to whether a case should be brought. If, for example, the president ordered the antitrust case to go forward after being told about the implications, there might be economic implications for the country. You know, if the case is brought, it could cause the stock market to drop or something. There are national implications that justify sharing the workup of the case. That's one thing. But if the decision is to go affirmatively, we'll take that aside, and the Justice Department says, we've been asked about this, we've been investigated it thoroughly, it's our professional judgment that we would not get past Rule 11, and on good faith, good basis to bring this case, we don't want to do it, and the president were to order them to bring it, then it seems to me at that point that would probably go all the way up to the Attorney General, and the Attorney General should be prepared to resign before bringing a case that would be unethical.
Yeah,
now, whether it ever gets to that level.
Unethical is easy.
Well,
because you have an independent duty to the court as officers of the court. But suppose, especially in the antitrust area, where enforcement is such a big part of policy.
Right.
Your view of the antitrust law so much is entwined into how active your enforcement policies are. Mm-hmm. If that's the case, then a president coming into power who believes in a more robust idea of antitrust enforcement cannot effectuate that policy vision against an incalcitrant antitrust division that is left over from the last administration. I think there has to be sufficient give in the system whereby the administration can effectuate its policy changes and has to take the political hit for those policy changes.
So it has to be transparent. You at least have to announce that it's the president who made this decision, not the Justice Department.
Or that the process is involved. I mean, I think that let's take a not so distant controversy, even though it's not really a controversy. There were some allegations that some career lawyers in the Department of Justice about the handling of tobacco litigation. for example. It may very well be. Again, I'm not involved. I don't know the facts other than what the Washington Post puts, which means I don't know very many facts. But the question is whether or not, if the president gets into or the White House gets into a conversation with the Department of Justice and say, hey, you know, this whole idea of states suing companies has significant legal issues that we may want to consider, and this whole theory of the RICO claim that is being pressed may be a big stretch. You know, let's pull the brakes on that. I think the controversy there is not whether or not it involves itself in the process, but rather it has to take the political hit for it.
Right. So, yeah, but you're sliding from a decision in a specific case to really a policy that would govern other cases, right?
Or one case so big that it becomes a defining policy for the administration. Microsoft has that potential. Tobacco has that potential. You know, I guess gun litigation would have that potential.
Well, the president often gets involved, and I was just reminded of this in cases where the Classified Information Procedures Act is implicated, because, I mean, a judge has ruled that this criminal case cannot go forward unless a particular body of classified information is declassified. Mm-hmm. So, I mean, you've got, and so you have the National Security Council and some prosecutors in a room, you know, where the president, and I think it should be the president, makes a judgment that, yeah, this prosecution is not going to go forward because we're not going to declassify this information because of methods and sources, or it is. And we're going to take a potential national security hit. So it's so you do get criminal cases in the White House, other, you know, in Noriega, and then sort of in the reverse area of the Jamie, like the SEPA cases.
You know, but you have, to follow up on all three of these comments, you know, you've got various dimensions here. There is a big distinction, I think, between involvement in a criminal matter and involvement in a civil enforcement matter. And there is a big distinction between saying, I don't want to press these kinds of cases, and directing that I do want to go after certain people or individuals. So let's take on the one hand, let's say hypothetically that after, say an Enron collapse, the president says, well, you know, I've got to do something, and I don't want more regulation. So what I'd really like to do is to be enormously aggressive in the prosecution of criminal cases. And I understand you've got the Arthur Anderson decision coming up. Just know that I'm counting on you to show the American people that we're strong on corporate criminal liability. You know, that gives me a substantial amount of pause. Now, I don't know if that conversation happened. I am making it up. But I'm just trying to illustrate where I have much more anxiety than I do about a president coming in and saying, well, you know, my view of antitrust is not the same as my predecessors. And I'm much more inclined to let mergers happen than my predecessor was. And therefore, that has implications for cases that are not going to be brought that might otherwise have been. That, to me, is on the other end of the spectrum.
I don't have any, you know, Viet talks about the ethics is the easy case. I'm not sure it is, but taking that for what it is, for the president to come in, and it happened in our, you know, the shift to the Clinton administration, the antitrust division started to get robust. The reason we hired David Boies to try the case was that the antitrust division had not tried any antitrust cases for years. And so they were terrific as second chairs and on, but there was nobody in the department, and we vetted that very carefully, you know, what we were signaling by bringing an outside counsel. But the point is that the Clinton administration made a point to be more aggressive on antitrust, more aggressive in certain environmental areas, in civil rights areas the prior administration may not have. It flips back and forth. That's a judgment that the administration is entitled to make, and to make those changes. But to get in and start micromanaging individual decisions that forces the professionals at the lawyers at the Department of Justice to have to bring cases that they would not, in good conscience, as whether it's ethical or just a matter of their legal judgment, would not feel that they could legitimately bring, even to effectuate the policy, be it the Arthur Anderson case or not. The analogy is somewhat, because we do have the White House counsel role, probably talk about at some point here, but when I was in practice as outside counsel to a corporate client who wanted to bring a lawsuit, I had a professional obligation, I thought, to give the information that was best suited to what that client wanted to accomplish. But at some level, I could not, as a matter of, now we are talking about professional ethics, go ahead and file a suit if there's no basis to it. And if you enlarge that, now you have in the White House, you have the White House counsel, who is in-house counsel now, the equivalent of in a corporate setting. You'd have general counsel.
So the Attorney General is the outhouse counsel?
And the outhouse. There you go. We always like to be called outhouse counsel. Now you have competing decisions, or perhaps you have White House counsel making their legal professional judgment, and you have the Department of Justice making theirs. And I'm not sure how that gets negotiated out when push comes to shove.
All right, so let's let's just shift over to the other side of the question, which is the relationship between the outhouse counsel, that is the Attorney General, and the United States attorneys, people in the field.
They're employees.
I'm sorry?
They're employees of the Attorney General. There is no other relationship.
All right. So that sort of, I think, signals Viet's view about the relationship. Is there anything that the Attorney General may not instruct a United States attorney to do? Bring a particular case where the Attorney General doesn't know the facts, bring a particular case against a political enemy of the Attorney General, bring a political case against the political enemy of the President? Are you still
Those all go to the
saying no?
mechanics of the decision, not the propriety of the communication of the decision. I mean, anybody should never tell anybody else to do something they don't know anything about. And so that's independent of the Attorney General versus U.S. Attorney. If the Attorney General is well-informed and has a different decision point than the U.S. Attorney, I think he's absolutely free to overrule the U.S. Attorney.
Is there any kind of conflicts issue that may exist at the national political level that doesn't exist, and maybe sometimes in the opposite direction? The United States that the Attorney General shouldn't be involved because it involves some national political issue with respect to the target?
Unless it rises to the level of recusal or to the requirements of appointing a special counsel, I don't see that to be a significant issue.
Does anybody disagree on that? There's certainly a tradition of not doing what I just suggested. That is,
yeah.
And why is there that tradition, and why do people get upset when there's a breach in that tradition?
The tradition is that the political leadership of the Department of Justice has as one of their main jobs protecting the traditional processes of the department, particularly with respect to the prosecutorial function. And the reason for that is that it is not a mechanical judgment whether to seek an indictment and prosecute somebody. It is a judgment that requires judgment, and it requires experience, and it requires understanding what we, the department, does and what we don't do. And therefore, I think it's very important to tread lightly and to be enormously respectful of the career people who have that tremendous well of experience. Now, it's not to say that, you know, any senior official of the Department of Justice is supposed to be chopped liver. You're not. You're supposed to probe and prod, ask questions. You can make policy judgments. You can say, I would like to see a greater emphasis on gun cases. You can say that. And you can say, I don't see that this is the right use of our resources within the department. But the essence of what you're trying to do is to protect that which is very precious and easy to wreck, which is the respect that people have for the use of the tremendous powers of the department. Once people believe that there is no discipline or no rigor, or that decisions are being made for political purposes, that respect for the department gets eviscerated. And once that happens, it can't do its job for the American people. And I don't know how, you can't describe it mechanically, But that is what the job is, in my appreciation, of a senior departmental official.
And just to underscore the stakes, I checked in the Ninth Circuit, the federal government is the litigating party in 64% of the cases that we handle in the Ninth Circuit. So
More in our circuit, Ray.
well, I can't understand why. But the reputation and the integrity of the Department of Justice, U.S. attorneys all the way up, because lots of AUSAs are arguing in front of us all the time on criminal and some civil, lots of immigration cases, Social Security cases, all sorts of cases that the Department of Justice or the government is being represented in our court and in Merrick's court, across all the federal courts. So the consequences of the reputation of the Justice Department are quite enormous, just as a reputational matter. We're talking about individual decisions, and I'm not saying that one bad decision in Philadelphia makes all the decisions in the Central District of California bad decisions, but it does undermine over time and over a number.
But
very important credibility.
Is this affected by how many times Main Justice intrudes in the U.S. Attorney's Office, or maybe who the Attorney General is as compared to who the U.S. Attorney is? So
I think it has to do with the dividing line between all of this. I completely agree with, by the way. It's all about just good management of a great organization. But it has more to do with the respect for the line attorneys, the divide between career attorneys and their political appointees, supervisors versus staff, and it has nothing to do with the U.S. Attorney versus the Attorney General. That is Main Justice versus U.S. AO. And by that position, I mean to say that there is, in my mind, no significant purchase to the argument that we often hear that U.S. attorneys have their own independent responsibility to local interests and districts and the like, that is somehow sacrosanct and therefore outside of the chain of command of the Department of Justice. It's just, you can't run a Department of Justice that way, period.
does it matter whether the U.S. Attorney is an experienced former prosecutor, reputation for, knowing what to do in a law enforcement situation, and the Attorney General is, I don't know. No, like to put it, look, so there have been attorneys general who have been the president's, the head of the president's campaign committee during the Nixon era. But, by the way, there have been U.S. attorneys who have been the head of the president's campaign committee in the local state. And this is true in both Democratic and Republican administrations. It's a bipartisan problem. Does it matter whether, in that relationship, who's the one who's the actual straight arrow with respect to how the public perceives or even as to how the direction should go?
Yes.
Okay, that's short. Anybody else? Yeah?
Well, the way it plays out at the U.S. Attorney's level is that the individual offices are shaped by whoever is immediately managing them. That person can be a hack or politicized or whatever, and that office will begin to suffer because the rumors and the reputations fly around the district courts very rapidly. It may filter up to the circuit level eventually. On the other hand, if the U.S. Attorney is fighting off a disagreement with an Attorney General who is trying to force the U.S. Attorney's office to do things that the judges think are really ill-considered, that can have some adverse effects. Now, I don't know whether that's right or wrong, because the administration does have to make its choices and has to inform them. But there are consequences. The point is they can't be ignored. And if somebody is undermining the credibility of the local prosecutors, where they're the ones that are having to stand up in court, they're the ones that are having to persuade the judges on the firing line, there ought to be a lot of respect, I would say, and a lot of communication before one starts to meddle in what's going on at the local level.
If someone in the criminal division came to me and said, so-and-so U.S. attorney wants to bring this prosecution that we don't agree with, we think the evidence is thin, And we also know that this U.S. attorney has eyes on political office, and could be using the U.S. attorney position as a stepping stone. I'm going to look hard at it for just that reason.
Well, I mean, and it goes without saying that there's lots of checks and balances at main justice at the non-political level.
Mm-hmm.
You know, as I understand it, a U.S. attorney cannot indict a sitting governor, congressman, et cetera, without a main justice sign-off. That I've heard a lot of, when I was White House counsel, a lot of career prosecutors at main justice would be apoplectic about special counsel pursuing legal theories that they wouldn't allow U.S. attorneys to pursue, I mean, novel interpretations of the law. So there is a lot of rigor and direction on the administration of justice. So it's not like you have 93 independent agents out there. There's a fair amount of
Try supervising.
A fair amount of supervising.
Well, before we turn over to the audience to ask questions, I'll take up on that point, independent agents, and I think this will be an easy question in light of what you've all said so far. So two very different people, Professor Will Marshall and Arnold Burns, who was the Deputy Attorney General in the Reagan administration, have both suggested in different ways that we should consider making the Justice Department quasi-independent. That is, something like Professor Marshall's suggestion, like a state attorney general being independent of a governor, and Burns' suggestion that the attorney general get a fixed term like the FBI director of some length of time. Anybody think this is a good idea on this panel? I take it by your silence. The answer is no. And therefore, I now open it up to the audience. We're open to any kind of question, but I would note that there have been 3 areas where there seems to be enormous happy harmony in the panel, and it would be nice if we got some disharmony from the audience. So one is that point about whether we should consider independence. Second is the question about the relationship between the U.S. attorney's offices and the Justice Department. And the third is about warning the president when there's an investigation, particularly an international investigation, that might impinge on somebody close to him. I don't mean by this to cut you off otherwise, but a little argument would be helpful.
Oh, we've disappointed you.
Hi. Wow, that's loud. I'm Jay Johnson. You were talking earlier about instances in which the White House tells the Department of Justice to bring a civil suit. To me, the most notorious example of that was the Pentagon Papers case, where the White House told the Department of Justice and told the U.S. Attorney to sue the New York Times. In terms of whether there's something an AG cannot tell a U.S. Attorney to do, I would ask the panel, what about the hiring of a line AUSA, directing a U.S. Attorney to hire a particular person as a line AUSA?
All right, let's start, if you don't mind, let's start with your first question, and maybe we'll get to the second one. So anybody see anything wrong, leaving aside the issue of whether the President was correct with respect to the Pentagon's Papers case, is there anything wrong with the communication from the White House to the Attorney General saying, file this case, there's national secrets being disclosed? Does anybody think that institutionally that's a problem?
You have to answer the history about it. You have to take the hit. But
I mean, assuming that there is a legitimate basis for the case and for the case being brought, and the people who are making the decision or participating in the decision have considered the implications for precedent, because if you assert a position that is soundly rejected, you can make bad law from the point of view of the department. It is the President's prerogative and responsibility to protect classified information, and certainly a lawsuit like that would be one way of implementing it.
And incidentally, one of the things that I would, if I were Attorney General, bring to the White House's attention is that we have a policy, a very good policy, that before any U.S. attorney sends out a subpoena on any journalist,
right,
you got to clear up the chain.
Right.
And if it was a New York Times, the reporter, you better be damn sure that the White House is alerted, because that's going to be a political brouhaha.
And it was one of the first brouhahas in the Carter administration when they subpoenaed William Sapphire's telephone records. And the cause, maybe that was the second or third scandal of the administration, but that was an early
I
one, and
think
that's
it's
what
prompted the policy,
That's what
actually.
prompted the policy, exactly right.
I didn't know
Second
Sapphire.
question.
Sapphire did not go quietly into the.
I didn't know you used telephone.
Second question.
Oh, yeah, you had a second question. Any problem with an Attorney General making a decision on a career appointment?
Yes. Yes, you can wreck the whole department if you don't abide by the policies, the well-regarded policies for the hiring of career people.
Yep.
Anybody have a disagreement over here? Anybody in the audience want to disagree with that? I take it nobody thinks that the Attorney General doesn't have the authority to do this, is that right?
No, I'm not sure. That's my first thought was what does Part 0 say? Because as because the U.S. Attorney.
Part 0, that's DOJ talk.
I know. Part 0 of the CFR sets forth all the components, the authority, and each U.S. attorney, despite my consideration of it as part of the chain of command, is the head of a component, and I think technically, as well as I understand it, the hiring and firing decisions rest with that head of component.
Right, but Part 0 is promulgated by.
Right, the Attorney General.
Correct.
Sure, I understand that. And so I guess you can't really direct. Technically, you do not have the legal authority to hire that person into into a person's component. But if somebody told me to do that, I'd probably resign before I take it. Right.
Merrick,
Yeah.
going back to the first question on should the president ever direct that a civil case be brought, I think effectively, and it won't be this administration, a future president will direct that a leak investigation will be pursued by focusing on the press, as Fitzgerald did in the Scooter Libby case, and not. Right now, the current policy is that the FBI has to look for the leakers, and that's a never-ending search, because Main Justice doesn't have the stomach, in my view, to ever bring one of those cases. And so, the FBI has to go back and constantly re-interview everyone who had, in the government who had access to the classified information. At some I think that's one of that in the Balco case is, at some time a president, maybe a president early in their first term with a pretty good mandate, and you've got a really serious leak. Certainly, I can see one from Vietz and my party doing it, would follow the Fitzgerald precedent.
Well, so that's interesting. That's an investigative method, actually. So you think that the president would or could or should not just direct that find this leak.
Which probably every president that
Every president has, yes,
said that.
correct. Some have provided the plumbers, right? So that, so that was an investigative method. It turned out not to be a very good idea, right?
We all agree on that.
Yes. But in this case, the Justice Department says, well, look, we have a policy that we don't start by going after the press. We start by going after our own people and finding out. We only go to the press in the where we've tried all other approaches, where it's a very important matter. Where on balance, the damage to the First Amendment interests, leaving aside whether there's a First Amendment law question, but at least interests, we don't do that. You think a president could, would, should say, I like this method better because actually the press caves and, the anonymous leakers don't. You think that would be okay?
Well, I mean, I think the real-life fact pattern that you'll see is that the president will say, 2 years of the FBI interviewing and re-interviewing the people who were read into the program's enough.
But they would probably have to go through that because at least until the qualified privilege concept generally, you have to make a showing that you have exhausted your resources.
Well,
Right, so leave aside the law question.
But anyway,
look,
getting into that.
there's a policy that could be rescinded.
Right.
There's a policy that says you know, we don't turn to the press in the first instance.
Right.
You could rescind it.
Right, so that policy was
My
adopted.
point was that whether you have the policy or not, it may be a futile lawsuit. You get in and the court
Judge
would
would
say
Yep.
it's premature.
Maybe, but I mean, that's actually not decided yet completely,
No, I
so.
know. Well, maybe in your circuit.
How would you decide that case, Judge Merritt?
Yeah, this is exactly why I want to stick to historical examples. But, so that policy which the Justice Department enacted, which is this balancing, was done after, was actually done after the Stanford Daly case, right? So the U.S. Attorney's Office in California sent out subpoenas for photographs, which the local Stanford newspaper, the university newspaper had. And that created a large uproar and actually legislation. There's Stanford Daily legislation, and then it led to this CFR, which has this. But the president could obviously direct the Attorney General to delete that CFR.
There are a lot of angry people out there who don't like what this panel is saying. We should let them in.
Okay, let's get some. Yes, here's an angry. Oh, there's an angry person right there.
I would just like to get some of the panel's views on the difference between the political appointees being able to present and implement their ideological views and policy views versus undermining some of the career attorneys and their efforts in enforcement. And this certainly has been an issue in civil rights now, but even just looking historically, so giving an example, back in the 70s after...
You picked a good decade. That's
so
good.
Desegregation, in Mississippi, there were all these cases that the Justice Department was pursuing local school districts to desegregate after Brown, and the Justice Department in a new administration basically said, well, we ought to, rather than making them go ahead and desegregate, you know, in September, let's give them some time and just delay these cases for a while because there's too much hubbub and resistance. And the Civil Rights Division attorneys who were in Mississippi that whole summer essentially, you know, had a revolt, and eventually the Supreme Court overturned that case. But, I mean, you see that in, you know, current terms, you see that over time. How much do you think the political appointees, you know, where do you cross the line when you are pushing a, you know, the president's policy versus undermining the career attorneys' efforts to enforce what they're supposed to be doing?
We can do that with that historical example. What do people think about that? Obviously, I take it the Nixon administration came in with a different view. Is that what you're suggesting? Yeah. Yeah, with a different view about how hard to push on desegregation, and probably with respect to whether you would go outside jurisdictions or not outside jurisdictions. Any problem with them saying to the career attorneys who wanted to go more aggressively, that's not our policy. We had an election. We said we were going to do something different, and we're going to do it.
I'll start by saying that the problem quite often is overblown because the only problem presents itself only in politically charged cases like desegregation and civil rights and the like, and people who have access to very good political tools. The one thing, and I say this, you know, sincerely and not as blowing smoke on anybody, is that it is incredibly surprising to me, being an academic, having never been set foot in the Department of Justice, of how incredibly professional the career lawyers are. They recognize the proper scope of their authority. They recognize the proper political mandate of a new administration, and where the two are not compatible, there will, in my instance, there will be conversations about how we deconflict that, or if we cannot deconflict that, how we can find an alternative arrangement whereby there would not be that kind of conflict. And I ran essentially a political shop. With many changes in policy from one administration for another. We went 180 degrees, some would argue, on gun policy. And the entire gun unit essentially became my policy staff because they recognize that their expertise is critical, even as the policies change, because their expertise would help, you know, guide the ship more steadily rather than cause a tremendous shift in the department's policy. So in that sense, I don't see there, at least in my experience, the conflict that we hear so often about in other divisions isn't presented as starkly, even though I fully expected for a complete fight and wholesale firings and stuff like that.
Well, there are, taking Vitt's point, but to take the example, it isn't as if it's just the President and the Justice Department setting out policies in school desegregation. There was Brown versus Board of Education. There was Green versus New Kent County on the freedom of choice rules that said the time to desegregate is now. So there's a mandate, in effect, from the Supreme Court. There are the 1964 Civil Rights Act. There are laws of Congress that the Justice Department and the President and the Attorney General are sworn to uphold, regardless of political party. They're there to enforce the Constitution. So there are mandates that run as a matter of law. Now, Viet said in the civil rights areas they have political power outside the courts. That may be, but that doesn't mean people whose rights are to be enforced by the Justice Department. There are acts of Congress. There are, as I say, mandates from the Supreme Court of the United States. And the career lawyers should be heard in that regard. And if they are out there in the field enforcing those and they're suddenly pulled out from enforcing the laws in local jurisdictions, that sends one heck of a message to the people whose rights that they're enforcing. The Justice Department isn't there just to implement the policy of each new administration. There are priorities, yes, but not to suddenly change the enforcement of the laws.
One data point to keep in mind as you think about an issue like this is that the Justice Department has the obligation to argue for the constitutionality of duly passed and signed acts of Congress. So you can have a statute that is being challenged in an administration that doesn't actually support that piece of legislation. And the Justice Department, nevertheless, must go to court to support the constitutionality, to argue for the constitutionality of that piece of legislation. Now that is, not a political act. It is an act that suggests an institutional.
There's some qualification of that.
Yes,
You wouldn't say any act that the Justice Department thinks is unconstitutional, they have an obligation to defend.
But if there is an argument, that's the position that prevails. I mean, in the Clinton administration, we took positions in court to sustain a challenge, sustain the constitutionality of pieces of legislation, which as a policy matter the President would not have urged. And I think that is just very telling about the role, that there are institutional obligations that do not change from administration to administration. Yes, you can put additional resources in a place that you want it to be. So we spent a lot of time on addressing the racially based church bombings and trying to protect abortion clinics from being destroyed. But you nevertheless have responsibilities that are institutional, and addressing that balance by listening to the career people and yet nevertheless bringing to bear the policy priorities of your administration. That's the hard part of the job. It really is.
You have any more rowdy questions out there? Yeah.
Judge Garland, which I'm very pleased that you remember since it occurred when you were in college. The ITT case was an example of all of the above and has a rich amount of history in respect to the current problems with the Justice Department. The Solicitor General and the Assistant Attorney General in charge of the Antitrust Division had decided to proceed with a serious set of antitrust cases against ITT. The allegation was that the White House had interfered with that process and had ordered those cases to be stopped. The allegation was, the person you mentioned, Dita Beard, that it was in exchange for $200,000 contribution to the Republican convention. There was a hearing because the acting Attorney General happened to be up for confirmation as the Attorney General. And if you want to Google this subject, you can just Google Kleindienst, ITT, and Dieter Beard. And he was asked the question, was there any interference from the White House? And he answered no. It later turned out that the President had called him directly and virtually demanded, ordered that this case be stopped. He was ultimately charged not with perjury, but the next thing below perjury for his statements to the committee. Executive privilege was invoked to cover all of the White House involvement, but eventually the White House, some White House aides appeared before the committee. Deliberative privilege was invoked in regard to the papers of the Justice Department, and eventually all of those papers, including the settlement decisional papers, were provided to the committee. But the point was that at several points, both the White House and the Justice Department tried to wrap a cloak of policy around the ultimate decision that was made, as though that would justify what was happening, which in fact was a payment in return for a decision by the Department. So on the one hand, I caution you not to rely too much on policy arguments as authority for some of this, but also encourage everybody, and thank Judge Garland for raising this case, to look at that case and look at those precedents and use that as a standard to judge what's going on now and what's about to go on.
My staff in the White House, and we had a lot of Nixon litigation going on over who owned his records and disputes with the archives and that sort of thing. And your old firm was involved, Jamie, but
in that case, Jamie took Nixon's side.
Yes,
very flexible.
But I think it's Peter Keisler who coined the phrase or the rule in Nixon's case, which is that Nixon always loses.
But not in Jamie's case, actually.
We did win that one, so.
We got a rowdy question out there, yes? Can somebody, yeah, can you give her?
My name is Jennifer. I was on the Ninth Circuit last year. Yes. My question is for the entire panel, and it's the main justice versus U.S. attorney's discretion question. And my question is, whose discretion trumps? Is it always main justice's discretion? Because I clerked out in Phoenix last year, and so I got to know Paul Charlton, and I find his case kind of sad, where he was a Bush-appointed U.S. attorney, and he, I think, got dinged for pushback on a death penalty case in which he did not want to seek the death penalty, if I'm getting this right, and main justice kind of overrode his discretionary decision, and he was basically strong-armed into seeking the death penalty. And I wondered what your opinions were on that, and is it true that if main justice's discretion always trumps, is Paul Charlton's discretion that's just a sad case? Because I know everyone in this room is, rooting for Paul Charlton in that case, but if the positions had been reversed, maybe we'd be like, good thing main justice keep an eye on these rogue U.S. attorneys out there seeking death penalty all the time.
All right, so the panel can answer that question if you just delete the name Paul Charlton
exactly.
from the question.
And also, I'm not sure the facts bear out that it's all or primarily
Right,
about
that's why I want to delete. The question is whose discretion wins.
I was going to bring up the death penalty example, but I thought it was too politically charged, so I'm glad that you asked the question, so I'm forced to bring it up as the thing. That's a classic case whereby I think that that makes my argument that the 93 U.S. attorneys' offices are not independent sovereigns of their own. That it is indeed there is discretion, but there's also parity across the nation and a matter of policy emphasis. It may well be that even though the law is there to be enforced, that some folks would use their discretion to look more wary at the death penalty requests. Some would think that the field offices some field offices are not requesting enough, and some are requesting too much. The difference between Texas and Connecticut, for example, may well be very, very stark. and you want to balance it out and use the same set of criteria, so a poor criminal in Texas does not suffer death, while a rich criminal in Connecticut gets life. And that's the kind of stuff that cuts across district that I think that justifies Main Justice involvement. These are obviously very serious decisions, so they cannot be taken flippantly, so you almost guarantee that a parallel process at Main Justice in order to weigh the pros and cons exists as rigorous, if not more rigorous, than at the local level. And so the traditional hesitancy about not having enough facts and not overruling line and the like would not argue so much, because the process at the Main Justice, I would imagine, would include a lot of line input if it is focused at the consistency level.
You know, all of these cases are hard. I mean, I don't think that you, as an administrator, would make a judgment based on any individual case. But, you know, if the president has a priority, if the president strongly believes in the death penalty as a matter of policy, and you have a U.S. attorney who, you know, over 4 years can't find any case that is heinous enough to seek a death penalty you know, my president had a real emphasis on pornography, and if you had a real libertarian, which you could get in the Republican Party, who believes there's a God-given right to read and view whatever you want in the privacy of your home and never bring a pornography case, then it would be appropriate to consider it, but not to step in and order it. I mean, just because it's the politically popular thing to do, you just. I think that's poor administration of justice. That's ineffective taking care to see the laws are faithfully executed. I mean, policy is one thing, micromanaging cases is another.
Okay, I'm afraid that I've just been given the low sign rather than the high sign. We're out of time.
Could we get one historical thing that I...
Yes, please.
We've not talked a whole lot about White House counsel, and I understand you have a personal relationship with the first White House counsel.
Well,
indirectly.
With her granddaughter, with his granddaughter, I do.
With his granddaughter.
And that's all I'm going to say. No, it's my wife. My wife. It's perfectly all right.
Well, the story is, there's nothing wrong with the story. It's just that when Roosevelt, I think it was Roosevelt, wanted to have a White House counsel type, the Attorney General Biddle didn't want that to happen at all, foreseeing the erosion of power. And so I guess when Biddle was traveling out of the Capitol, Roosevelt appointed Sam Rosenman as his White House counsel, and that is, in fact, Merrick's wife's grandfather. Right.
But it gives you an idea of how things have changed. He was not only the White House counsel, he was also the White House legislative advisor and speechwriter, and he had nobody working for him until they brought over this guy from the Navy named Clark Clifford to be his deputy. That's how it began. So, thank you all very much for coming. We appreciate it.